Good afternoon. We have another case to basically help us adjust status. Okay, arriving aliens. Even if you are not an arriving alien, but we want to make sure that you adjust status based on the fact that you were paroled into the United States under humanitarian parole, the 212D5. Okay, that's the humanitarian parole. So that's the case we want to talk about. Okay, I've been talking about it, adjustment of status for arriving alien. This is the deal. I'm gonna say it a little bit clearly so that you might be able to understand what I'm talking about. If you came to the border, okay, and you were placed in expedite removal, which means that you went through this credible fear interview. After that, you were placed into full proceedings. The general rule is that ICE has to detain you until the day of the final decision of your asylum case by an immigration judge. Let's say you go to the immigration court, the asylum gets denied, you go to the BIA denies asylum, you should be in detention. The moment they release you before all is over, that type of release, regardless of what the paper says, it is considered humanitarian parole type of release. It's released under 212D5. And based on that, you can adjust status if you marry a U.S. citizen, or if you have a child who's 21 and over who's a U.S. citizen. Or if you are underage, then you have parents who are U.S. citizens who want to petition for you. Basically, immediate relative type of relationship, you can adjust status. Okay? And where exactly are you going to adjust status? That will depend on whether you are a arriving alien or whether you are not a arriving alien. Let's say you are an arriving alien. It clearly says it on the notice to appear. And there's argument to be made if you are a arriving alien. Those are the arguments you have to make, those type of argument on the day of your master hearing. If you miss that, it's over. You no longer have that argument of whether or not you're a arriving alien. But let's just confirm for the purpose of this video that you are an arriving alien, and it clearly says it here on the notice to appear. However, it doesn't show that you were paroled. So what exactly can you do? The thing that you can do is to look at the way you were released, the procedure. You came at the border, you were arrested, detained, got to pass your credible fear interview. It's called expedite removal proceedings under 235B. So that's questioning at the border, where the officer will question you. Once you pass it, and then they give you a notice to appear, okay, to see an immigration judge. So if they release you before the entire case is over, it is considered humanitarian parole, regardless of what the paperwork says. At that point, you can adjust status with USCIS, because remember, arriving alien, parole to the United States, adjustment of status jurisdiction is with USCIS, despite being order removed. Okay, as long as you DHS has never executed that order of removal. Refer back to my video of yesterday. But let's say you are not a arriving alien, but still you meet the parole requirements in terms of you were released prior to the end of the trial, of your asylum trial. Meaning what? Meaning you came to the border, you get arrested, detained by ICE, they place you in expedite removal proceedings, meaning that you're taking those questions for to pass your credible fear interview type of questioning. Once you passed it, they give you a notice to appear in order for you to appear in court, even if they didn't give you the notice to appear. But anyway, you have a date in court, and then they release you. The moment they release you, that release is considered humanitarian parole type of release. and you can adjust status in court because the judge has jurisdiction. Remember, you're not a arriving alien, so the adjustment of status is in court when the case is open. But if the case is not open, what are you going to do? Again, we refer back to old procedure. You're going to have to join us, terminate removal proceedings, so that you can adjust status with USCIS. Or you can file a sua sponte motion with the court directly, which is really hard. But anyway, that's a second option to terminate removal proceedings and adjust status with USCIS. That's how it's going to play out. So this is a great case. This matter of Q Lee is basically talking about, it's not really talking about in terms of adjustment of status. It's just talking about the fact that this person was claiming that they were parole under humanitarian reasons. It was humanitarian parole, but unfortunately for them, for that person, the judge said that of course it was humanitarian parole, but the fact that you got arrested the second time, that parole was terminated. So you are not eligible for bond, so you cannot request bond. But this case is just good for adjustment of status in terms of it's reiterating, basically trying to reiterate the things that we've been talking about here as far as am I eligible to adjust status based on the fact that I was paroled in the United States. How do you know it? Again, look at the way you were released. It will determine whether or not you were paroled. I've been talking to a lot of people about it, but now that we have another case to supplement the cases that I've been talking about, this is the time to adjust status, my friend. This is the time, and this is 2025 under this administration. So this is the time to actually adjust status if you came to the border. And even if you didn't come to the border, but you're arriving alien and you were released before the end of the trial, you were paroled to the United States, period. And you can adjust status with USCIS. If you're not arriving alien, again, you can adjust status with the judge if the case is open, or else you have to terminate the case, terminate removal proceedings and try to adjust status. This is really good news. This is really good news, especially under this climate, okay? If you have questions or you want to schedule a consultation, please schedule it. Please schedule it. I talked to a lot of people about this adjustment of status. They were just so confused. My friend, this is the time, schedule a consultation so we can use this case to argue, so you can adjust status, especially if you're an arriving alien with an order of removal. We can just go directly to USCIS with this case. If you're not, then it's gonna be complicated in terms of trying to terminate removal proceedings. You can hold on, but if your case is open, in terms of you have a court hearing and you have I-130 approved already, we can go straight to court and adjust status with the immigration judge. This is it. Until next time, I am going to make my video about detention because I really want to talk about detention. I never mention it in on my videos, but I want to talk about it because, you know, we're dealing with people in detention and we just want to give them some hope and kind of explain the procedures and how it actually plays out when a person has been detained. Until next time, bye-bye.